Workplace Class Action Litigation Report webinar. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down as it will not be reread and is required for CLE credit. Copies of the webinar recording and materials, along with the CLE attendance form, will be distributed to attendees in the days following the webinar. At this time, I would like to turn it over to Jerry Mattman. Jerry, please go ahead.
Thank you so much, and thank you to our attendees for joining us with this year's annual webinar with respect to workplace class action developments. I'm joined by three of my partners, and it's a real privilege to be here with them. I would like to introduce one of them, Ian Morrison, who is the chair of our ERISA Employee Benefits Litigation Group and one of the foremost ERISA class action litigators in the United States. He's handled cases virtually in every state around the country. He writes books on ERISA, gives presentations and training on ERISA, and Ian is going to focus today on those aspects of ERISA litigation that we found to be important in 2020. Thank you, Ian, for being here.
Thanks, Jerry. It's an honor to be here again for another one of these webinars, and also to be joined by my partner, Brett Bartlett, who is co-chair of Seyfarth's National Wage and Hour Practice Group, and he's defended hundreds and hundreds of complex class actions in the wage and hour space, and routinely advises employers about wage and hour issues, and helps keep them out of litigation as well as defending them when they get into litigation. Brett's been recognized in numerous media outlets as a leader in this area, and recognized as a BTI Client Service All-Star on many occasions, and Chambers rated and one of the most innovative lawyers in America. So welcome, Brett. It's an honor to be on this panel with you.
Thanks a lot, Ian. Really appreciate it. And Jerry, thanks for the opportunity to talk to all these fine folks. It's my pleasure to introduce Carrie Fredericks. Carrie is my go-to for all things California. She's a partner in our San Francisco office and vice chair of our National Wage and Hour Litigation Practice Group. She draws upon many years of experience focusing on wage and hour law, almost exclusively assisting clients with all aspects of wage and hour compliance, including developing and implementing a variety of pay structures. Carrie works with clients across industries, focusing on healthcare, technology, and financial services industries, with a particularly strong background representing clients in the healthcare industry, given her particular understanding of the context in which hospitals operate. This helps her develop practical, workable solutions to compliance matters. Carrie?
And I'll introduce Jerry Mattman. As many of you may know, Jerry is a partner in our Chicago and New York offices and co-chairs our class actions practice group. And once again this year, Jerry has achieved a litany of remarkable accomplishments in the courthouse, and still somehow managed to author yet another edition of Seyfarth's annual Workplace Class Action Litigation Report in his spare time. Jerry's 2020 was highlighted by a number of precedent-setting victories in substantial class actions throughout the country, ranging from outright dismissals to persuasive arguments in federal appellate courts, and the dismantling of massive class and collective actions. As an example, Jerry secured the dismissal of 2 nationwide RICO class actions brought against employers in New York and Illinois, both of which presented novel, first-of-their-kind issues. As a result of this success, and for the 5th time in 7 years, Jerry was selected by Law 360 as an employment MVP, which is an award that recognizes the top 5 attorneys in the U.S. in each respective practice area. Given the selective nature of this award, it's exceedingly rare for one lawyer to be selected multiple times, and Jerry has won this award more times than any other lawyer in the country. And just this past week, Chambers recognized Jerry's work in its 2021 global rankings, stating that Jerry is absolutely phenomenal and one of the top class action minds in the country. And with that introduction, I'll hand it back to Jerry.
Thanks so much, Carrie. Very kind remarks. Next slide, please. Will show the tour of the workplace world that we would like to take you on in the next hour. We've divided it into 6 categories, and these are trends or takeaways for you to think about at your companies in terms of what we found to be significant in 2020 and what we see peering around the corner coming down the road in 2021. So first, we're going to take you through kind of what has been hot on the next slide in the workplace world. And I think that's pretty easy to say. There are 2 things. The first would be COVID-19, what it did to government, what it did to the legal process, what it did to lawsuits, and then just the concept of change. The year 2020 certainly was a year of change, especially with the election and the flip of the White House from red to blue, and how that will impact employers, how that will impact federal and state enforcement agencies, and how that will impact the private plaintiffs bar. So I think that the 2 C's, COVID and change, what we thought were 2 significant drivers with respect to the workplace class action world in 2020. Next slide, please. So counterintuitively, one would have thought in the COVID year and the problems with companies and cash and layoffs of workers that settlements would ground to a halt. And in somewhat counterintuitive fashion, it was the largest settlement year, greatest settlement amounts since we've been tracking it, and settlements went up. Government enforcement action went way down, yet at the same time, with respect to cases that were in the pipeline, those settlements went up. And then with the all important, what we call success data, or the number of instances where plaintiffs' attorneys filed class actions and were successful in converting them to certified actions, which in this instance is the holy grail of what they're trying to do, because a certified lawsuit as a class action has weight, has leverage, and often results in a settlement just due to the exposure presented by that. In 2020, the certification rates, the success factor, was the highest it's ever been in the 17 years that we have tracked the data. So those are some of the highlights of what we saw in 2020 that we're going to get into in more detail. Next slide, please, for Ian.
Thanks, Jerry. One of the data points we look at each year is the number of employment and workplace lawsuits that were filed in a given year. And this 2020 was the 2nd year in a row that filings were down across the board in ERISA, FLSA, and employment discrimination. And some of that is undoubtedly due to the COVID-19 pandemic and the courthouses being closed and law offices being closed, but there may be other levers at work on those numbers, and we'll see that play out during this year. The question remains whether we'll see an uptick in cases that have been pent up for the last 12 months. So next slide, please.
Thanks, Ian. This is Brett. So we saw a number of trends affecting class action employment law litigation in 2020. First, and perhaps the most obvious, was COVID-19. If it affected every aspect of our lives, and it certainly did, it in many ways affected the workplace and how employers and employers related to one another in an even more significant way. Telework and other remote work became commonplace for businesses as they tried to save jobs and frankly to save themselves. Many, of course, had to trim their human capital, which was tragic and painful in many instances. And not surprisingly, we saw litigation spawning in part as employers were making hard decisions necessary to their survival, with more than 1,000 COVID-related workplace lawsuits filed in 47 states, and more to come if our predictions are correct in 2021. Next slide, please. Here you can see a map of the layout of where we saw the impact of COVID-related lawsuits. The plaintiffs' bar focused the lawsuits in traditionally employee-friendly jurisdictions and filed 181 or 18% of these suits in California, followed in numbers by New Jersey that had 150, Florida 95, New York had 68, and Ohio had 66. And if you'll turn to the next slide. And we're still looking at the impact of the COVID-19 pandemic on litigation, and really reflecting the creativity of the plaintiffs' bar. In the lawsuits filed to date, plaintiffs have asserted 46 different issues or theories of liability, with 5 primary theories as the key drivers of this workplace litigation, including alleged failure to provide a safe working environment, discrimination claims, particularly relating to disability and age, leave claims under the FMLA, and the patchwork of federal, state, and local laws enacted in response to the pandemic, retaliation, and whistleblower claims, often attached to either a workplace safety or leave issue, and wage and hour lawsuits arising out of the pandemic. Next slide, please. And understandably, in-house legal professionals overwhelmingly cite workplace liability as the biggest legal risk they face related to the global health crisis. The lawsuits were spread across a broad array of industries. And you can see the chart here with the highest numbers targeting healthcare and business services, as illustrated by the chart that's up above on your screen. Employers of all industries and sizes, however, are continuing to ready themselves for workplace litigation that they anticipated still in the pipeline as the new theories developed in response to the pandemic become part of the fabric of workplace litigation for years to come. Next slide.
So the theme of this year really has been change is the new normal. And dealing with COVID-19 is not the only way that change became the new normal in 2020. We also saw the effect of recent pro-business court rulings, including the very significant 2018 Supreme Court decision in the Epic Systems case. As many of you know, this decision allowed for the enforcement of agreements to arbitrate employment claims and led to a significant increase in the filing of motions to compel arbitration, and also an increase in the willingness of courts to uphold these agreements. These trends demonstrate that bringing motions to compel arbitration can be a very effective way to defend lawsuits and to reduce litigation costs. Next slide, please. And while the good news is that the employer-friendly leadership of the EEOC will remain in place for now, we are anticipating significant legislative and regulatory changes with the new administration. One effort we are likely to see is proposed legislation to amend the Federal Arbitration Act and overturn Epic Systems, which would have an obviously huge impact on the workplace class action landscape. We also are already seeing some very significant activity at the Wage and Hour Division of the DOL that evidences a shift toward more worker-friendly wage hour policies. For example, the DOL already announced its delay of the implementation of the prior administration's independent contractor regulations, which were set to roll out last month. And just last Friday, the DOL withdrew the 2019 opinion letter that it had issued addressing independent contractor status in the gig economy. So while we can already see that worker classification is on the DOL's immediate radar, the DOL also is fielding many requests in connection with other issues, including raising the minimum wage, narrowing the application of overtime exemptions, and addressing worker classification issues more broadly, including in the area of joint employment. Given all of this, 2021 is definitely going to be a year to watch the DOL, and we'll continue to learn more about the new administration's priorities as the year unfolds. Next slide, please.
So taking us on to our third trend of 2020, remarkably, the aggregate monetary value of workplace class action settlements increased last year, as settlement numbers went up and as plaintiffs, lawyers, and government enforcement actions monetized their claims at higher rates. Many employers and commentators alike expected the pandemic to depress the size and pace of settlements and the new cash is king approach to the business cycle. Instead, workplace class action litigation defied the odds. The numbers show that the plaintiff's bar was successful in converting case filings into significant settlement numbers at higher rates than the past 2 years. After settlement numbers reached an all-time high in 2017, they plummeted to their lowest level ever in 2018, before experiencing a mild recovery in 2019. This past year, settlement numbers continued their upward trend in several areas, signaling a return to prominence of these best company cases. Next slide, please. Now, these statistics are interesting to me that you see on this slide. Clearly, we are still talking about tremendous amounts of settlement dollars in the aggregate. What I notice, however, is that wage and hour settlements have fallen, especially relative to employment discrimination settlements. On the wage hour side, I have to wonder if that's a mark that arbitration programs and class action waivers have had an impact on class and collective actions following the Supreme Court's ruling in Epic Systems that Carrie just mentioned. And perhaps it's a mark of the societal trends highlighting the challenges facing women and those not in the majority in the U.S. workforce. Jerry, Ian, and Carrie will talk a little more about the year-over-year trend lines in these categories, and I'll turn it over to Jerry. Next slide.
For employment discrimination cases was, to me, one of the surprises of the past year, insofar as the settlement numbers were the highest they have ever been, which I think somewhat reflective of the social environment in which corporations are now operating and how their market share can be damaged by allegations or claims of systemic discrimination, and how decisions sometimes are made to settle litigation because of that exposure or because of those societal trends. Another way to view these numbers is in 2011, the Supreme Court issued its famous Walmart v. Dukes decision in terms of creating new barriers and a higher bar, so to speak, to certify cases. And cases that become certified typically then get settled. And so it shows you the ingenuity and the innovation of the plaintiff's bar to figure out workarounds when it comes to Walmart. And in that respect, in the past 12 months, probably the plaintiff's bar reached the zenith of its ability to work around those standards and nonetheless ring the bell, so to speak, when it came to settling employment discrimination class actions. Next slide, please.
And we can see from this graph that the increase in settlement numbers was not limited to settlement of discrimination class actions filed only by private plaintiffs, as we can see the same trend with respect to settlements of large government enforcement actions. This chart shows that the value of the top 10 government enforcement actions each year is showing a trend upward now. After reaching a very high peak of nearly $500 million in 2017, we saw a pretty steep drop-off in the value of these actions over the past 2 years. But then in 2020, we saw the same jump that Jerry just described in enforcement action settlements that he had described in connection with the settlement of employment discrimination class action settlements by private plaintiffs. Next slide, please.
And on the ERISA front, we saw a slight uptick in the total settlement dollars year over year, although as the chart shows, we're lagging well behind the period from 5 to 10 years ago when settlements in retiree medical benefits and church plan cases were working their way through the system and generating really enormous numbers. This year's portfolio of top 10 settlements was a fairly diversified group, including a top hat plan lawsuit that was the biggest of the settlements that we reported, a couple of employee stock ownership plan and prudent investment cases. The biggest number of these settlements, and we can expect this to continue for the near term, were in 401k fee and investment suits. There were about 80 of those filed last year. And those will be driving the settlement numbers going forward. And then there was just one church plan case in our top 10. So a bit more of a diverse pool of cases, but the ERISA plaintiffs bar has maintained a strong toehold in the settlement arena. Next slide.
And we can see here that the upward year-over-year trend did not actually hold for wage and hour class action settlements. The value of those settlements in 2020 actually fell off significantly from 2019. In 2020, the value of the top 10 wage and hour settlements was $294.6 million, compared with $449 million in 2019. Although 2020 showed a significant decrease over the past year, the value of wage hour settlements did hold slightly above the lowest levels that we saw over the past decade, which were between 2012 and 2014, and then again in 2018. Next slide, please.
Thank you, Carrie. We're now on to trend 4, and that is government regulation and government enforcement litigation. And in the final year of the Trump presidency, the number of lawsuits filed by the EEOC, the prime workforce and bias enforcement agency, were way down. The lowest number filed during the last 4 years of the EEOC, down to 94 merits lawsuits. And although Title VII and ADA cases were in the majority in terms of the filings, this is what you might call a Trump effect in terms of viewing litigation as a last resort. So next slide, please. Janet Dillon was the chair while President Trump was in the office, and she was on record for shifting the focus away from systemic litigation involving large numbers of employees and characterizing litigation as the last resort. I think that's off the table now. That won't be true during the Biden administration, and the barriers and things that the EEOC had done over the last 18 months to de-emphasize litigation are going to turn around, and I would expect quite an uptick with respect to litigation. Somewhat again, though, counterintuitively, the EEOC recovered more, $535.4 million in the past year than it had before. Cases again in the pipeline, something of the notion of clearing the decks and trying to reduce the amount of litigation out there and to settle a great majority of it. Next slide, please. The EEOC had also issued various regulatory enforcement guidance memoranda, the two most important being with respect to enforcement of systemic theories in litigation, the other being a memorandum of understanding with the Department of Labor and the Department of Justice to strengthen the coordination between those three agencies. And I think that what you are going to see under the Biden administration, both the DOL, the EEOC, and the Department of Justice, will be a renewed, enhanced emphasis with respect to rights of workers and use of litigation, not as a matter of last resort, but really as a matter of first resort in terms of vigorous enforcement of the statutes and the pursuit of significant damages remedies in terms of its deterrent effect. Next slide, please.
While we did see a slowdown in governmental enforcement actions in 2020, the DOL and the NLRB both issued significant workplace policy guidance and rulings this year. For its part, the DOL was very busy responding to COVID-19 and the impact of this crisis on the workplace, and spent much of 2020 issuing and enforcing guidance on implementation of the Families First Coronavirus Response Act, or the FFCRA, with the Wage and Hour Division continually updating FAQ guidance on the Act in response to the many questions and issues that were raised by the business community. The NLRB also took some significant pro-employer policy steps in 2020, ruling that an employer may discipline workers for making profane, abusive, or offensive statements, so long as the employer's action is not motivated by anti-union animus. This ruling reinstated the previously reversed right-line burden shifting analysis. And the NLRB also issued a final rule on joint employment, providing that an entity may be considered a joint employer only where the two entities actually share or co-determine the employee's essential terms and conditions of employment. Next slide, please. And this graphic illustrates another very significant trend that we saw in 2020, which is an increase in certification of wage and hour class and collective actions. There were 314 class certification decisions in 2020 in all areas of employment law. And the area in which we saw the greatest number of decisions certifying class and collective actions was in the area of wage and hour. Of 286 wage and hour certification motions, plaintiffs won 84% of the time, which represents the highest rate of success for the plaintiff's bar in over 16 years. Unfortunately, we expect this trend to continue into 2021. Next slide, please.
And here, illustrating the differences in class certification battles in different kinds of cases, you'll see that 84% grant mark, which is kind of an alarm bell for employers, I think, showing the high percentage of cases in which courts conditionally certified collective actions using a very lenient standard. You know, looking at employment discrimination cases, the odds are slightly favorable for employers. In ERISA cases, it flips on the other side. But it is important to note that this high percentage of wage hour conditional certification wins for the employees in the plaintiff's bar is because of the lenient standard that most courts apply across the land. And I'll talk in just a minute about that when we get into some of the case law. But for now, I'll turn to the next slide. And Jerry?
Thank you, Brad. This map illustrates what I believe to be the theory of location and how location or a jurisdiction is a driver. And if you sort the data, and now that we've been doing this for 17 years, we have data of over 20,000 rulings. What that illustrates for employers is they're more apt to be sued in 4 of the circuits, the 2nd and 9th on the Atlantic and Pacific coasts, and then the 5th and 6th in the middle of the country and in the south middle of the country, because that is the epicenter of especially wage and hour class and collective actions, and where the numbers flip in favor of the plaintiffs to a higher degree. This map is a little busy, but basically shows you a comparison over the last 2 or 3 years and how plaintiffs' attorneys continually reach into these 4 circuits as their favorite circuits to bring their cases, and that the law in those circuits is developing in a manner that probably is the most pronounced as pro-plaintiff. Next slide, please. If you look at those numbers with respect to employment discrimination, where Brett pointed out the lowest success factor holds, that success factor nonetheless was above 40%, whereas in past years, it was down in the 20s. So plaintiffs are clearly doing a better job. But as you can see, the number of wage and hour cases outstrips by tenfold the number of employment discrimination class actions that are brought because of the amount of money, time, effort, and activity costs that need to be sunk into those cases to have a chance to certify those. Next slide, please.
And on the ERISA front, the numbers are seemingly a little bit contrary to what Jerry and Brett said about the distribution of rulings, but obviously we've got a much smaller sample size in this pool. Generally, circuits that have been favorable on class certification have included the 5th, the 10th, and the DC Circuit. And then the 2nd Circuit is probably the hotbed of plaintiff-favored certification rulings in ERISA cases. As Brett noted, plaintiffs are fairly likely to win certification in an ERISA case. Courts are very receptive to the argument that the conduct at issue cuts across an entire class of participants, and where the defendants have won on certification motions, it's mainly been when they've been able to demonstrate that there's some conflict between class members with respect to their respective preferences. I'll also note that courts are becoming more receptive to the concept of not needing a class certification in an ERISA breach of fiduciary duty case. ERISA, on its, at least theoretically, allows plaintiff to sue on behalf of the entire plan, and several courts have adopted that rationale and said certification is not really necessary here. I can issue a plan-wide ruling without it. So something to watch out for as the year moves on. Next slide.
Thanks, Ian. I don't want people who are listening in and watching our presentation to take the low settlement dollars in the aggregate for FLSA wage hour cases as a suggestion that there's little risk in the wage hour world. In fact, I look at numbers on this slide and I just find it remarkable, particularly that some commentators are suggesting that the risk is diminishing in the wage hour space. I mean, look at 2020. Sure, it's the lowest number in quite some time, but that's still more than 6,000 FLSA cases filed nationally. That's a tremendous amount of risk, particularly when you consider that oftentimes the fees that are expended in these cases exceed the recovery that a single plaintiff might try to secure. So making sure that your house is in order remains so important. Carrie, thinking about California, are you seeing similar trends and similar risk?
Well, I'll just add that in California, we have such an active plaintiffs bar. We continue, 2020 was no exception to recent years, and we saw, many filings of wage and hour class actions in state and federal courts, as well as many PAGA actions. Many of you have been dealing with PAGA actions, either filed alongside class claims or as independent representative actions. So we expect to see that trend continue in California. Next slide, please.
And before we go on any further, we would like to announce the CLE code for today's presentation. The code is SS, as in Seyfarth Shaw, SS 3476. Again, that's SS 3476. And I will turn it back to our presenters.
Now we're going to take a tour of the class action world in terms of rulings. We had a very challenging situation in front of us, which was to pick out the most significant cases that illustrate what has been going on in the courthouses in each of our substantive areas of employment discrimination, wage and hour, ERISA, and some miscellaneous cases. And so you'll see on this first slide, not only the site of the case, but a page number. And what that page number is where in the Workplace Class Action Report, all 880 pages of it, where an analysis of this particular case is. And if you don't yet have the book, the address to download the ebook will be on the last slide of the presentation. It's free. A lot of people use it as a research tool and bookmark it. It's fully searchable. You can run searches within it. And so when you see the page number, what we're talking about is where it can be referenced in the report. So I thought on the employment discrimination front, there were 3 decisions that really teach what's going on and the struggle that employers and plaintiffs have in these cases when battling over certification. And I thought that these 3 illustrated it best. And there are 3 cases where employers beat motions for class certification and the cases went away. The first was the Pace Suburban Bus case, which was a race discrimination case with respect to the imposition of discipline. And the plaintiff's theory was that disciplinary decisions were made based on race, and more African-American employees were given discipline, put on PIPs, terminated, not given pay increases, all because of this decision-making when it came to discipline. The employer was able to defeat class certification by relying on the notion that the review of an employee's performance and how they adhere to personnel policies and how they perform their job and whether or not discipline is appropriate in the circumstances is truly an individualized issue that a single person can't get on the stand, tell their story, and it automatically transposes to everyone else who's in the same class. And so here was a situation where the judge said on multiple levels, due to the lack of commonality among the people, due to the lack of a typical sort of claim and how individual issues would predominate, that for all of these reasons, multiple reasons, class certification should not be allowed. The Harris decision is a case that went up on appeal, and it's where the district court certified an ADA case involving a fitness for duty rule. And the theory of the district court was it's one rule applied by the company uniformly in the way in which it's interpreted that impacted the class members, employees who had disabilities. But yet on appeal, the Eighth Circuit said the ADA and issues regarding fitness for duty and the ability of someone to return to work is a loaded, individualized question that depends on the limitations or impairments that a particular plaintiff might have. And therefore, the district court erred in certifying a class, and the Eighth Circuit vacated that award. It's probably the leading ADA class certification ruling that I've seen in the last 5 years, and probably the starting place for any employer sued in an ADA case that has class-wide allegations. The last case, actually, the name of the case is Case versus Judd, involved a veterans' right case, and the issue of whether or not discrimination occurred when promotions were handed out in Florida by an employer, and if active duty or non-active duty military veterans were disadvantaged in this particular situation. And many commentators, I think, probably thought this was a case where the case would be certified, but the judge did not certify the case. And it was one of the first rulings of the year just before COVID came out. And basically the judge's theory was there was no uniform way in which decisions were made, and there was no one person making the decisions. There were many, many people making decisions about many, many employees. And so the lesson there for the plaintiff's bar is to make the cases smaller, tighter, involving one decision maker or one policy that cuts equally against all people. So it was a good year for employers, and these three decisions kind of illustrated the victories that employers had and the way in which they were able to use the Walmart decision in a way in which to end these lawsuits. So next slide, please, in the wage and hour area.
Yeah, and I'm happy to talk about some significant wage decisions, but it's always so hard to choose which ones to talk about in a presentation like this, because over the course of the year, as you see from the stats, there are so many cases filed and there are so many important decisions that come down the road. This year, I decided to select the first two on here to illustrate a point and to really delve into the facts of the cases. I will say that both of them involve the question of whether a court should conditionally certify a collective action, and both of them involve the battle of evidence between the plaintiffs and the defendants to try to show that there either was no unlawful policy that applied to everyone whom the plaintiff wanted to include in a collective, or there were differences that existed so significantly among putative collective members that there could not be a case that would ever proceed to collective action trial. Again, applying that lenient standard. In Thrower, the court looked, and by the way, these are two cases from Texas, although distant parts from one another. In Thrower, the court looked at the evidence presented to support the plaintiff's motion for conditional collective action certification, saw that there were material differences existing among the members of the collective the plaintiffs wanted to certify, and recognized that those differences were fairly material, and it conditionally certified them nonetheless. It really is disheartening to see when there is clear evidence that there are dissimilarities that exist among putative collective members, but applying that lenient standard, the courts across the country tend to conditionally certify. And then in Wittenberg, another court took a look at similar evidence. It was that battle between the plaintiff and the defendant, and found, contrary to what the court in Thrower found, that the plaintiff's self-serving declarations didn't show that there was an unlawful policy that would have bound everyone together. So they weren't similarly situated, applying the same standard. Kind of confusing within the same state, within the Fifth Circuit, finding that two collectives, approximately the same evidence, one was conditionally certified, one was not. And that's terrible, obviously, as you're trying to predict risk in these cases. And it just illustrates that even in the Fifth Circuit, that we think of as at times employer friendly, courts were leaning in favor of conditional certification, and the second case, Wittenberg, was just an exception. But I will point out, and because we're talking about 2020, I won't get too far into this 2021 decision, but the landmark decision, Swales versus KLLM Transport Services, came down from the Fifth Circuit earlier this year and found that that lenient standard is not appropriate at all. That courts should be considering all of the evidence, should even be looking at merits evidence, and should conduct a rigorous analysis to determine whether people are similarly situated before permitting a case to go on as a collective action. It's a tremendously important decision. The Fifth Circuit left open for the district court below to figure out how exactly the standard would apply, how discovery would come into the mix. So we don't know where that's going to land, but I'll tell you, I'm looking at that case in every case that I've got in the Fifth Circuit and certainly beyond. I'll note two other cases fairly quickly. In Canada, a judge in Tennessee found that the Supreme Court's decision in Bristol-Myers Squibb foreclosed it from exercising personal jurisdiction over the defendant as to out-of-state collective members. And it's a really important decision too. There at the lower court, it'll be even more important eventually because that case is on appeal. There was a split within the circuit, and that issue is also on appeal in the First Circuit, and I believe in the Eighth Circuit as well. And so we may end up seeing a circuit split, which could push the question of whether Bristol-Myers Squibb applies to FLSA cases to the Supreme Court. And then I'll just call out the Schlumberger case, also a Fifth Circuit case. There have been a lot of important Fifth Circuit cases in the past year or so in the wage hour world. In that decision, it's a rare decision by an appellate court upholding an employer's refusal to produce privileged information that involved a classification review. Fairly detailed procedural posture there. It doesn't apply to every set of facts, but it's an important case to be aware of because we all, as employers and employers counsel, want to make sure that we're reviewing job classifications and pay practices in the right way. There's always a concern, is the privileged communication about those types of reviews going to be disclosable in subsequent litigation? At least in this decision under its circumstances, the Fifth Circuit found that it was not. But obviously California's got a lot going on too. Carrie, do you want to talk about those cases on the next slide?
Yes, and that is definitely true. As I mentioned before, the state and federal courts in California always have full dockets of wage and hour class actions, and 2020 was definitely no exception. We saw a number of interesting decisions out of California courts this year, and I'll just cover a few of the more significant decisions. I'll start with some good news. Two decisions out of the Ninth Circuit, Castillo and Davidson, addressed the required showing that a plaintiff must make to certify a claim based on an allegedly unlawful policy or practice. In Castillo, the Ninth Circuit affirmed the district court's denial of class certification, where the defendant employer demonstrated that individualized issues regarding whether employees actually suffered any injury from the challenged practice would predominate over any common questions. This case involved claims that the employer did not calculate the overtime rate of pay at the correct rate under California law, which is always a challenge for California employers. While the Ninth Circuit held that there was a common question of whether the formulas that the employer used were lawful, it found that the plaintiffs failed to meet the predominance requirement because an individualized analysis would be required to determine whether any of the employees actually suffered any injury as a result of the practice. So that was a very, very helpful case for employers facing these types of uniform regular rate of pay claims. The Davidson case is another Ninth Circuit case that illustrates that it's not enough for a plaintiff just to cite to an allegedly facially defective policy in order to establish uniformity for class certification purposes. In this case, the plaintiff claimed that the employer's rest break policy lacked certain language that she claimed was required for the policy to be valid. However, she presented no evidence that she nor any other employee actually was denied a rest break in violation of California law. The Ninth Circuit affirmed the district court's denial of certification, emphasizing that a plaintiff must affirmatively demonstrate that there actually are common questions of law or fact, and this requires more than just simply identifying the existence of an allegedly facially defective policy. The Santos case out of the Northern District is another decision that supports that plaintiffs must submit actual evidence of uniform unlawful policies in order to obtain certification of wage and hour claims. In this case, the court denied certification of the plaintiff's meal and rest break claims, where it found that the plaintiff had used a very small and hand-picked sample of employees to try to prove the existence of a uniform unlawful practice. And the court determined that this was not sufficient to permit an inference of a uniform policy. The plaintiff in this case also tried to argue that the fact that the employer's timekeeping records showed near uniform, very high level of compliance actually proved that there was falsification of records, or at least permitted an inference that the timekeeping records had been falsified. And fortunately, the court rejected this argument, much to the relief of employers that actually are able, through their diligence, to obtain a high rate of compliance. The court rejected the plaintiff's argument and held that evidence of compliance can't be used to provide a basis for certification on the grounds that somehow reflects a uniform policy. And finally, the Barriga decision is less good news. It's important because plaintiff's attorneys are going to use this case to argue that courts must carefully review all declarations that an employer submits from current employees in support of the employer's opposition to class certification for evidence of coercion. The plaintiff in this case had moved to strike all of the declarations that the employer had submitted in opposition to class certification, and the court denied that motion, finding that it did not have authority to strike those declarations. It also denied certification on a wide variety of grounds, even apart from that evidentiary ruling. The declarations that the employer had submitted refuted the very existence of the policy that was at issue in the case, which was an alleged policy that employees were shut into the work site at the end of the shift and therefore were required to work off the clock. The lower court in this case had found that no evidence of coercion in connection with these declarations, and there was no evidence in the record that there was such coercion, but nonetheless found that it had lacked the authority to actually strike the declarations. The Court of Appeal reversed this decision and remanded, holding that the lower court had the duty to closely review the declarations for evidence of coercion or abuse, and found that just the existence of the employer-employee relationship and the dynamic of that relationship could potentially lead to coercion, and that because of that, courts have a duty to closely scrutinize these declarations. This decision was very particularly given the absence of facts showing coercion, but we can expect that plaintiffs will cite to this case in support of arguments that courts must very carefully review declarations submitted on behalf of current employees in support of opposition to class certification. And next slide, please.
So on the ERISA front, Jerry gave me a big challenge and told me to pick out 4 ERISA cases to talk about, and my reaction was there were 4 Supreme Court cases. Do you want me to talk about those for an hour? But I will keep it brief and pick more of a variety of cases here to cover the waterfront in the ERISA space. The Torres case is one of the first of the so-called mortality table cases to reach certification stage. These are cases in which the plaintiffs allege that when pension plans convert one form of benefit to another form of benefit, they use outdated mortality tables that understate life expectancy, which can shrink the amount of benefit that you get. And the Torres decision is important because the court there adopted the defense argument that some participants in the plan might actually prefer the older mortality tables, that it might work out for them to be a better benefit, better deal than the change that the plaintiffs were proposing. And the court said, if you want to change the plan to shift the mortality table to a different type, it needs to benefit everybody. It doesn't, I'm not going to certify this class. The Thole case is really critical, and it probably guts a whole line of potential ERISA class actions. The case involved a challenge to a defined benefit pension plan investment. Basically, what had happened in the financial crisis was that the plan at issue here had lost a lot of money on some investments. The plaintiff sued on behalf of a class of all the participants in that plan and said, you made imprudent investments, you owe the plan a bunch of money. The company in response basically topped up the plan and put in enough extra money to mean that there were going to be no benefit shortfalls, and then moved to dismiss the case. And the courts ultimately, the Supreme Court ultimately found that the plaintiffs had no standing to sue because, in the words of the Supreme Court, defined benefit pension plans are essentially contracts. And until you can show that the plan is not going to pay you the benefit that you're contractually owed, you don't have an injury in fact and don't have standing. And this is really critical because ERISA gives exclusive federal court jurisdiction over breach of fiduciary duty claims. So having no standing means you can't sue. So this is going to make it really hard for plaintiffs going forward to bring cases of that type. The Salima case, on the other hand, was more of a win for employees. ERISA has a unique statute of limitations that basically says the statute of limitations for breach of fiduciary duty runs from the earlier or is the earlier of 6 years after the conduct at issue or 3 years after the plaintiff has actual knowledge of the breach. And courts all over the country had disagreed over the years and the decades about what actual knowledge meant. Was notice enough, or did you have to actually know that the law had been broken? And the Supreme Court grappled with this language, saying this is unique, there's no similar statute of limitations out there. And so they turned to the dictionary and concluded that what actual knowledge means is that the plaintiff has to have in fact been aware of the breach. And the defendant in this case was saying the plaintiff was aware of the breach because disclosures had been made to plan participants, including the plaintiff, showing that these investments that were being challenged were in the plan and what the problems were. And the court said that's not enough. But it did say, defendants, you may be able to prove actual knowledge sort of through traditional means. Maybe you can bring forward enough evidence to make the fact finder believe the plaintiff knew what they're now claiming they didn't know. And so this is putting a lot of emphasis now going forward on making sure that participants not only get, but read plan disclosures and that you have some record of them having read them so that you can use that to defend yourself and shorten the statute of limitations. And then finally, the Ramos case is a 401k fee case that reached trial in Colorado last year. The court issued about a 100-page decision after the trial that's really good read if you want to learn what passes muster and what didn't pass muster in front of one district court judge in the 401k fee and expense arena. The plaintiff started out challenging just about everything under the sun in connection with this plan and sought $85 million in damages. The court ultimately found that most of the claims failed. In particular, there was an imprudent investment claim where the court rejected that, saying that the fiduciaries had really done their due diligence and made reasonable decisions. But the court found fault with the plan administrator's monitoring of record-keeping expenses for the plan and concluded that there had been some missed opportunities there. But it rejected the plaintiff's damage theory and damage experts, so that's totally implausible. And the court then proceeds to construct its own remedy that neither party had advanced based on what the judge found to be at fault. And so at the end of the day, turned the $85 million demand by the plaintiffs into about a $2.5 million judgment plus interest. I'm sure the decision will be appealed. Will be interesting to see how it turns out, but it's kind of an interesting cautionary tale for employers who are facing 401k fee cases that you may be able to pick apart most of it, but the judge may latch onto something entirely different and rule against you on that piece. So Jerry, do you want to tell us about the next slide?
Sure. There were a couple miscellaneous decisions we thought were important for you to take account of. One was the highest fee award. It was a consumer case, not an employment case, but $93 million in terms of the attorney's fees awarded to a consortium of plaintiffs' firms in Louisiana. The next case, the Massey case, involved what I think is a blueprint that the plaintiffs' bar is going to be using in 2021 when attacks are going to be made against employers that their return to work policies, or once the workers get back in the workplace, that safety protocols are not where they need to be. It was a class-wide injunction actually granted with respect to mandatory COVID safety protocols. It was the first one in the country, and it's been copied almost in every state by the plaintiffs' bar, and similar cases being brought. And then the last one was a workplace issue involving the gig economy, where the First Circuit upheld a district court decision saying that last mile drivers for Amazon fell within an exemption to the Federal Arbitration Act and therefore were not bound by the Arbitration Act. And that follows on the heels of the highest court of the United Kingdom last month ruling that gig economy drivers were employees, not independent contractors. And then just yesterday, the United States Supreme Court turned down a bid by a gig economy company appealing one of these rulings from the Ninth Circuit. So that issue and how it's sorted out and what will happen with gig economy workers is one to keep a watch on in 2021. Next slide, please.
So the next question really is, what do the developments from 2020 mean for employers in 2021? Well, first, we know, as Jerry was just discussing, there's a COVID litigation time bomb that is ticking. And when things get back to normal, or at least the new normal, we can definitely expect more class action lawsuits addressing COVID issues. We're already seeing this trend in many areas, including wage and hour, as plaintiffs' counsel identify new theories that are based on the novel issues that employers have had to face in connection with dealing with COVID in the workplace. We also know that plaintiffs' lawyers are very upbeat due to the results they obtained in 2020, including their success in obtaining certification of class and collective actions. And when we couple this procedural success with the movement of workplace agencies toward more pro-worker protections, we expect that 2020 will be a year that will likely further embolden the plaintiff's class action bar. Next slide, please.
So what can employers do? I think on this slide in the last 3 minutes, we want to give some tips, some toolkit items in terms of what employers should be looking at and thinking about in terms of compliance and litigation prevention. The best sort of workplace class action result that I know is that it's never filed and you never have to face it. And to me, that's all about very solid HR fundamentals, because none of these things should come as surprises. If you have sound grievance procedures and complaint procedures and investigation procedures, you can root out these problems and prevent them before they mushroom into larger class actions. I think in this day and age, the issue of should I not utilize workplace arbitration agreements is something that you should consider. Over 50% of employers have them, and I think some of the numbers that we saw in cutting down on filings or certifications was as a result of those arbitration agreements. And then I think knowing what your data says and what the data flow means in terms of how you hire, how you promote, how you pay, how you terminate. And then the number one thing is invest in compliance. A dollar spent in preventing these litigation problems is far better than spending $10 and having to defend them. And obviously the number one area that plaintiffs' lawyers are focusing on these days is how an employer pays and compensates workers. Ian, how about briefly in the ERISA area?
Sure. The continuing focus needs to be on fundamentals of fiduciary diligence, making sure your plans are being well monitored, that you've got the right advisors to support decision-making, and that you really understand, the fiduciaries understand how the plans work and how the service providers are compensated. A new one, as I alluded to in the disclosure vein, is now thinking about what can you do to not only get participants to read disclosures, and there was some joking at the Supreme Court arguments in the Salima case about the fact that nobody, including most of the Supreme Court justices, actually read the stuff about their retirement plans. But getting participants to read that is essential not only for their own benefit, but to protect the company by making the disclosure. So what can you do to create a track record of participants getting and reading materials? Brett and Carrie, on the wage and hour front.
Yep, I'll just say it's important to train those managers to audit for off the clock, audit as well for classification of employees as exempt versus non-exempt. Reach out to us. We've got a great FLSA handbook that has all kinds of audit materials at its back. So call on us. Carrie, you want to cover a couple things?
Sure. I'll just add that given the focus on worker classification, both at the state and federal level, it's been a huge, issue in California over the past couple of years, and we can see already that it's worker classification is very high on the DOL's agenda. We would really recommend that all employers closely review their independent contractor arrangements and contracts, and also evaluate their workforce for potential joint employer issues. And then finally, we would recommend just continuing to pay attention to litigation trends with respect to particular job classifications and claims filed in different industries, just to stay a step ahead of litigation whenever that's possible. Next slide, please.
And then finally, on employment discrimination, I think for me, it is adverse impact analyses. And if you're not running them, the government may in the future. That's going to be the soft spot that plaintiffs' lawyers are looking at, so probably can't underscore that enough. Next slide, please. We've reached the end of our hour together. This is the contact information for the report. It's free. You can download it. Love to have you subscribe to our workplace class action blog, where we write about this every day. I'd like to thank my three partners for presenting today, and thank all the members of our audience for taking an hour out and listening. So have a great day, and thanks so much.
This concludes today's webinar. Thank you for attending.